everybody. It's Meredith and Stacey from Saltovation. It's been a minute since we put out a video, new content anyway. But we're here today to bring a few recent rulings and cases to the forefront to give you some information, because these are centered around services and the sourcing of services for income tax purposes or franchise tax purposes. And this is a topic that we don't see a lot on, but incidentally, we probably will start seeing more. And it's actually, I think, a good thing that we're starting to see more and more guidance on how to source revenues, because in the service-based business, because as any of you who have been doing this type of work for years and years, you might be familiar with the income producing activity rules, the greater than cost performance rules, market-based sourcing. And those rules are written pretty broadly and kind of more art than science. And so now we're starting to see some states actually put some parameters around it, around those rules, whether good or bad. And so we're seeing some taxpayer wins and some taxpayer losses. And so we just wanted to bring some of these to everyone's attention. As time goes on, we might see more and more on this. So with that, we're going to talk about Arkansas, California, and Texas today. These are three states that have recently put out some guidance, like I said, whether it's rulings or cases. And I guess we'll go alphabetical since we are state and local tax people. So I'm going to start with Arkansas. So Arkansas recently put out a ruling based upon it was an audit assessment for the tax years 2014 through 2016. This taxpayer was audited. They were a corporate taxpayer. What happened was that a couple of interesting issues that came out of this ruling are one around nexus and the other around sourcing. And so what I found interesting, and some of the things that, if you've been following us, we tend to hone in on this with our clients, is that Wayfair, while a sales tax case, I think has had some unintended consequences for income tax nexus. And so what, incidentally, in this ruling that this ALJ put out, was that they did look to the fact that Wayfair has really brought, a different type of nexus, or looking at nexus differently rather, through e-commerce. And so what this case, what this ALJ, the judge looked at was whether Wayfair, kind of the consequences of Wayfair, in a service-based business, right? Meaning that this particular corporate company, they actually received commissions on sales, and some of those end users or end customers happened to be in Arkansas. This particular corporation had no property or payroll in Arkansas, was only receiving commissions from end customers in the state of Arkansas. And the taxpayer tried to argue that they didn't have enough presence in Arkansas in order to even have a filing duty. But the judge ruled against that by basically saying, no, you had enough of an economic presence in the jurisdiction because they had enough sales, they had, systematic and frequent, not visits to the state, but systematic and frequent interactions with customers in the state. They also they had maintained, they had enough of a market in the jurisdiction such that the state or the department determined that they had the requisite nexus. So that was step one. Did they have nexus? Company tried to argue against it. No, lost. They had nexus. Well, then taxpayer said, okay, well, if we have nexus, we don't believe we have an apportionment factor because we are earning commissions, which is basically providing a service. And Arkansas's rules, if you read their statute, they use the income producing activity test, but they don't use a greater than cost performance test. They don't use even a proportional cost performance test like some states do. It's really based on the income producing activity occurring in Arkansas. Well, incidentally, what happened was the department determined that even though the statute is written a certain way, and even though for this corporation, the services were basically performed all outside of Arkansas, the fact of the matter is that they were earning receipts from customers in the state. And so what the department did was they basically invoked their alternative apportionment statute and said it was more representative of the sales activities in the state to source them to the end customers. And so we've got a situation here where the department pretty much had the authority, and a lot of states have this authority. Their department has the authority to implement alternative apportionment, and most of the states do have alternative apportionment statutes. And so we've got a situation here where the state did that, and therefore taxpayer lost. So this is a taxpayer loser, unfortunately, and we'll have to see whether it is actually appealed, because it was an ALJ decision and the taxpayer could always appeal.
Well, and unfortunately, right, Stacey, the ruling that's out there is redacted, so it's hard to kind of know from a, value perspective, right? Like, did they exceed $100,000, or did they exceed some
Right.
kind of, arbitrary, what in the amount does Arkansas deem to be sufficient enough when we don't have those numbers available to us, right? Because they don't have the traditional factor presence that Alabama, Colorado, California, Michigan all have. And so it's very, kind of up in the air as to what those actually mean. Like you had said before, there are, we talk about as practitioners, what are you doing for Wayfair and how is that going to impact you from an income tax perspective? Wayfair was mentioned in this, but the audit really is related to 14, 15, and 16. And we know that Wayfair didn't come out until 18. So it's kind of interesting that they reference Wayfair, but the years in question have nothing to do, Wayfair wasn't litigated at that point.
Right. And like you said, I mean, Arkansas doesn't have a factor presence threshold, so it's not as if they have a $100,000 rule for Wayfair that then is for income tax nexus.
Yeah.
Their doing business standard is very broadly defined, like most other states.
Mm-hmm.
So that's another reason why I think the taxpayer lost here.
Yeah. Well, and also that kind of, which could be a good transition to what we're going to kind of talk through next with California, is that customer's customer concept, right? Where, the company who is kind of creating or is receiving the commissions could be based in California, Colorado, pick a state, non-Arkansas. They could be earning commissions or being paid by a customer in non-Arkansas, right? But their customer is selling product that is giving rise to the commissions to customers in Arkansas, right? So that's kind of this from, it sounds like the court's position, or the department, whatever you want to call it, is the, customers concept, that look through provision under the alternative apportionment method. And a lot of people also ignore Arkansas, because they tend to not be prominent in the population perspective.
Correct. Right.
But
they're not a big population state like our Californias, our Floridas, our Texas, our New Yorks. So, but
so then I think with that, that's a good kind of transition to talk about what happened in March in California, that the Franchise Tax Board has come out with a legal ruling that looks at how you should, or gives kind of guidance as, or clarifications as to some existing statutory language on how you are going to assign gross receipts from the sales of services. So we have, and we have a lot of clients that this applies to, that the way that the statute reads is that you kind of, their statute is related to the benefit of service, right? But who is ultimately benefiting from these services, and, looking to the customer's customer. And, some kind of opinion pieces, kind of interpretations had come out where, is there that possibility that that customer's customer, some people were reading it such that the customer's customer concept would go away, But as we are looking at kind of the law, what California kind of gives this like tiered approach to who is, first you looked at who is your customer, and then what is the service being provided, and then what if is the benefit of the service being received by that customer, and then where is that benefit being received. And so they outline some examples. They have kind of these 4 criteria to look at when you're determining your kind of services. And so the way, Stacey and I interpreted that under the examples is that customer's customer concept doesn't go away. It almost more so, really builds that case as to you do have to look through for the ultimate benefit.
Yeah,
Um,
and I think one of the things, my takeaway with this, and just for the edification of everybody, this legal ruling is 2022-01, and it was published March 25th of this year. And one of the things that I have kind of noticed in this is that they talk about who's getting the direct benefit as opposed to maybe an indirect benefit. And maybe that's why they wanted to put this out as a little bit of a clarification, because perhaps there's been taxpayers out there that have been kind of taking that rule and extending it to the customer's customer maybe unnecessarily, because indirectly maybe a customer's customer has benefited from a service, and that customer's customer could have been outside of California. So therefore California is not getting some of those receipts. So I'm kind of reading this as looking to who receives the direct benefit. But again, to Meredith's point, there's plenty of taxpayers and situations out there where the customer's customer are the ones that are directly benefiting. And we have clients that are in the advertising space. We have clients that are in, kind of like wildfire defense space. And so therefore, if you look to see who they're contracting with, it might be somebody who's outside of California. So the bill to would be outside of California, but the customer's customer are receiving the benefit of those services, those advertising services, those defense services in the state of California. So there are definitely situations where you can still look to the customer's customer.
right. So in that kind of example, if, you know, we are engaging with an insurance company that happens to be in Wisconsin, right? We send all our bills to Wisconsin, but when you think about the impacts of, fire prevention or natural disasters related to, heat and whatnot, we could be sending a benefit to Wisconsin, but we know that the insurance company insures homes in California, Texas, the parts of the country that tend to, be subject to climate change. And so it's not, the benefit could be insurance company in Wisconsin, but really they're actually deriving the benefit by having their homes protected or their policyholders protected in those, California kind of West Coast states. So yes, there is some benefit in Wisconsin, but the ultimate benefit is really tied to, that value of those protected policyholders, you know, not Wisconsin. Um, and so I think, what I would imagine is under audit that the franchise tax board is almost going to like almost have this as a kind of checklist, right? Where we're going to start like checking, like answer these questions and going through that. And then you're arguing over, okay, well, who actually is your customer and what are you doing and where? So might not be entirely helpful or really a change, but I think this is going to provide some more like steering the conversation from, you know, where things are happening.
Yeah.
But always still ambiguity and always still like points of contention.
Right. Well, and I think, kind of going back to even how we just, introduced this topic, is this sourcing it's been kind of nebulous. And so I think these states are starting to kind of look at it. And California usually is one that puts out some fairly good guidance for other states to look at Whether they choose to is a different story. But as practitioners, we tend to look to them because they do put out a lot of good guidance that we can glean some things from and apply to different situations. And so I think we'll start to see more and more states put out guidance on this, and or in the flip side of the, like with the Arkansas example, it might come down to how they audit it and what comes out of that. So
Right.
we'll see.
Well, and then kind of our next transition on auditing and interpretation, right,
Yep.
is Texas. And I think Texas has actually gotten a fair amount of press, quote unquote, for, lack of a better term, right? We're state tax people. So like notoriety is, up in the air. But right, so SiriusXM, is known as a, very popular satellite radio company that you subscribe to. You have to pay for, satellite radio. And um Sirius and Texas, from their statutory perspective, says it's the fair value of services performed in state. Okay, cool. Great. What does that mean? So Sirius said, okay, well, the fair value of our services, what people are paying for, is our content, right? And there's only one show that actually is produced in Texas. So we will allocate, the costs associated with producing that show happen in Texas. Everywhere else is, non-Texas. So they got audited. The, you know, the comptroller said no, we're gonna kind of essentially go to where your subscribers are. Originally, the trial court said no, we're gonna agree with Sirius. So it was a win for them. Comptroller appealed. So in the appellate court, they said no, the radio signals are actually decrypted where the receivers are, which is generally going to be, in the cars and where their, transponders, radios are. And that's generally going to be where the subscribers are. And so Sirius was like, okay, that's kind of BS, because who's paying for Sirius XM for decryption services? And so this actually went up to the Texas Supreme Court, and the Texas Supreme Court said, no, people, subscribers are actually paying for that content, and kind of agreed with the original position of Sirius, which was, a great win, which is a great win for them. And what I thought was really interesting is, one, how, oftentimes you don't find that rationale and kind of like typical consumer thinking is applied in these rulings, but that, the court said, and I'm going to read this for a second, characterizing the service Sirius performs for Texas as, quote, decryption of radio sets in Texas is like saying the service performed by the Wall Street Journal online is a, quote, payroll removal service, rather than the creation and distribution of news and opinion content its subscribers want to read. So it's like, yeah, I don't pay, we have Sirius in both of my cars. We're not paying, like, I'm paying so that I can listen to ESPN and Kids Bob while I'm driving through the country. I'm not paying for the decryption of that. And so the actual, like, practical application is something that was almost refreshing when you read this case.
Agreed. And not to mention the fact that, as opposed to like the Arkansas case where the department decided, oh, we're just gonna, use our alternative apportionment method, and, then the taxpayers kind of stuck with it. Well, unless they appeal, the Supreme Court was said, no, our statute says what it says, and we're not gonna deviate from that. So you're right. It's absolutely refreshing. So we'll just have to wait and see whether the legislature, though, decides to change anything there.
Which we do know that, like, when we have talked about this earlier, Tram's written some articles on this that, Texas is in kind of that digital space, going back to, trying to get to a market-based sourcing. So it's kind of like just change statute. If you want to be market, cool. Like, I don't care. Just let us know how you want it to do. And like, it's really hard to, what is, you know, what industry is going to fall into what bucket.
Right.
And in that digital space, it's like, is it a traditional service, which we're going to look at the fair market value, or is it more of, because I think the statute has always defined computer services as like a market base. So it's like, but who is what? Just pick one and change it for everyone.
Exactly. Be nice if everybody's consistent, but then wouldn't be nearly as interesting.
No, certainly not. So I'd be curious, do you think, Stace, that Texas is going to try to appeal this further? Or are they just going to leave the Supreme Court ruling and just kind of chalk it up to a loss?
Well, I don't know. I guess we'll see, right? I mean, they'd have to take it up to the Supreme Court, our Supreme Court now, right? I mean, and as everybody knows, I mean, they don't hear too many tax cases, although, Wayfair definitely was a tax case. But that was 2018. So, I guess we'll have to wait and see. But I think probably what will happen is that the legislature will
Change
start
it.
take a look at the rules and change them. That's my guess.
Yeah, I would agree. I was like, I don't
Because
know
they're
that
already,
it's
to your
worth the
point,
loss.
yeah, to your point, they've put out, and everybody listening to this may or may not know this, but they put out some regulations that have clarified how they um, want taxpayers to source certain types of revenue.
Yeah. So I'm more of the, like, just change it. Right. You're one of the few states even anymore that still has kind of a ratio or a cost perspective. And so it's, at this point, I think there's maybe even like less than 10 that are either greater COP or a value of services or a ratio perspective. So it's just like, just almost just jump on the bandwagon and let's go. Let's just,
Yeah, yeah.
you know,
Although then, as we kind of highlighted with the California, it's okay. Well, what does that benefit of the service really mean, right?
fair.
So then we get into that. But I guess the point being here, and what we're trying to just highlight to everybody, is that none of this is easy. It's a little bit of a moving target, and I guess we'll wait and see whether more states address, either through audits or legislative changes, et cetera, um, how they define sourcing of services, and whether we see more and more litigation in this area too.
Yeah, truth. Well, we will stay with it, and you can follow us at Saltovation, and we will update you as best we can. We also have kind of articles that went out. I think we pushed each an article about Texas and Arkansas and all three of these. So you can find our written word on Saltovation, and we will see you next time. Thanks, everyone.